Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hello everyone, welcome to another podcast. I've got 3 cases for you this month, really spoiling you. 2 on warranty claims and then 1 on unfair prejudice, both of which I think seem to be quite hot topics at the moment. There seem to be quite a few cases working their way through the courts on those subjects, so we'll have a look at those. And then once we're done with the cases, I thought I'd just briefly explain some proposals to narrow the scope of the Takeover Code in terms of the companies that code applies to. So first up, let's get into these warranty claim cases. And the first one that I've got for you is a Court of Appeal decision in the Court of Appeal looking at a case that I've talked about before. I think it's the Drax and Scottish Power case. So here, the Court of Appeal overturned the decision of the High Court and held that a notice of warranty claim was valid and it complied with the relevant requirements of the share purchase agreement. So when giving warranties to a buyer under a sale agreement, the seller will usually negotiate various contractual limitations on its liability under those warranties. And those limitations will usually include some sort of requirement for the buyer to notify the seller of any potential claims within a specified period, and then perhaps a little more detail about that particular notification. So some sort of requirement for the buyer to include reasonable details of the claim and how it's being calculated in that notice. If the buyer fails to comply with those requirements, then that can result in the claim being unenforceable and therefore the seller avoiding liability, regardless of, if you like, the merits of the actual underlying claim itself. So it's almost like the buyer fails on a technicality by not managing to comply with the notice provisions, even if actually it's got a perfectly valid claim underneath. So the courts have taken a sort of increasingly strict, and I think some would say quite harsh, approach to the interpretation of these claim notifications, requiring a very formulaic compliance with the contractual notice provisions. And the fact that the Court of Appeal in this latest judgment has now overturned the first instance decision and its reasons for doing so, which we'll come on to, may indicate that the courts are willing to adopt a bit of a more pragmatic approach to these cases in the future. So, the facts in this case: the buyer, a company called Drax, had acquired a target company from Scottish Power, the seller, under a share purchase agreement, and the buyer subsequently brought a claim against the seller for breach of a warranty in that agreement. So, as I've just explained, the agreement required any notice of a warranty claim to state in reasonable detail the nature of the claim and the amount claimed, detailing the buyer's calculation of the loss thereby alleged to have been suffered. So that was what the buyer had to do. So when the buyer brought a claim, the seller applied to dismiss that claim on the basis that the buyer had failed to comply with the notification requirements. The notice of claim that the buyer submitted included the required calculation of the buyer's loss, but that calculation in the notice had been based on an estimate of the losses that the target company was expected to suffer due to the warranty breach. Once legal proceedings had started, the buyer actually sought permission to amend its claim and base its loss not on the losses that the target had suffered, but on the reduction in the value of the target shares that had arisen from the warranty breach. So the seller said, well, the buyers had claimed for a completely different type of loss than the one it actually specified in its original claim notice, and therefore the claim notice was invalid. So when this came before the courts originally, the High Court agreed with the seller and held that the buyer's notice of claim didn't give reasonable detail of the loss claimed and how that loss had been calculated, and therefore it was void. In the judge's view, the fact that the buyer's claim had been based on the diminution in value of the target shares was both part of the nature of the claim, remember that the notice had to state, and also an essential part of the explanation required to provide the necessary reasonable detail of the amount claimed. And the fact that that had not been included in the buyer's original notification of claim, and therefore the claim had no real prospect of success because of that. So the buyer then appealed, and the Court of Appeal has now unanimously disagreed with the High Court and has allowed the buyer's appeal on the basis that the notice of claim had, in fact, satisfied the requirements of the agreement. So, in relation to that wording about having to state the nature of the claim, the court said that the buyer didn't have to spell out that its claim was based on the diminution in value of the target shares resulting from the alleged breach of warranty. And actually, if you impose that kind of requirement, it served no commercial purpose and would really just introduce a trap to defeat what may be a valid claim. So, exactly that point that I was making, that you can end up as a buyer sort of failing on a technicality. But the Court of Appeal said no, all that's required is just a simple statement that the seller had failed to ensure that the target had the benefit of an option agreement, as it had warranted in this particular case. And then, in relation to the amount claimed, the court found that the buyer's notice unquestionably stated the amount claimed and provided details of how it had been calculated. Even though the buyer had not originally based its claim on that reduction in value of the acquired shares, the claim notice had in fact set out the buyer's genuine good faith calculation of the claimed loss, and that was all that was required, the court said. That genuine calculation didn't have to be set in stone, helpfully. And if further reflection by the buyer indicated that the calculation was capable of improvement or was legally unsound, then there was no reason to insist that the buyer should be held to the particular method of calculation set out in its original notice. So it's an interesting decision, this. It slightly bucks the trend of recent cases, and I think it's going to be very welcomed by buyers. It suggests that the courts might be increasingly willing to interpret claim notices in a slightly more pragmatic, maybe less legalistic manner. And very helpfully, I think the court said that notification clauses should not become a technical minefield to be navigated, divorced from the underlying merits of a buyer's claim. And I think that's a reaction against the direction of travel that we've seen in recent cases. And like I say, it is a bit difficult, I think, to reconcile some of the Court of Appeal's findings with those previous decisions, particularly in relation to its conclusions on that wording about the nature of the claim. So, in previous cases, the courts have been clear that the buyers have to identify the specific warranties that have been breached when setting out the nature of their claim. But the Court of Appeal was not convinced that that was necessary. And its conclusions, the Court of Appeal's conclusions now, I think, suggest that provided the recipient of the notice has enough information to assess or prepare for any impending claim, then that would actually be sufficient. So ultimately, whether a buyer's notification of claim is going to be satisfactory will depend on the specific contractual requirements of the agreement. I think despite this recent, much more buyer-friendly Court of Appeal decision, buyers would still be very well advised to err on the side of caution and provide as much information in their claims notice as they're reasonably able to do so. Again, based on the language of the relevant clause, taking that into account. So that's going to include things like the type of claim being brought, i.e., for breach of a warranty, what provisions of the contract are alleged to have been breached, so actually specifying the particular warranties where possible, and then the buyer's genuine estimate of how any loss has been calculated. But it's an interesting decision, which, as I say, slightly bucks the trend, and it'll be one to keep an eye on to see what happens in subsequent cases now. Okay, so then in another warranty related case, the High Court this time has held that a contractual time limit for bringing warranty claims under a share purchase agreement did not begin to run until after the quantum of earn-out consideration had been determined. And only at that point would the relevant warranty claims become actual or quantifiable claims as required under the agreement. So, as a reminder, we're looking here at some earn-out consideration. What's that? Well, it's just a form of deferred consideration paid by the buyer to the sellers after completion, but based on the target's post-completion performance. So in this case, the buyer acquired a group of telecommunications services businesses. So initial consideration was paid on completion based on a multiple of the target's EBITDA. And then, in order to bridge the expectation gap between the buyer and the seller regarding the target's value, with obviously the sellers thinking their company and group is fantastic and worth a lot, and the buyer perhaps being a little bit more cautious about whether or not the projected results are going to be delivered. So, to bridge that expectation gap, the agreement provided for further earn-out consideration to be payable if the target's EBITDA in the 12 months post-completion exceeded an agreed threshold. And then, as is normal, the agreement contained a number of warranties from the seller to the buyer in relation to the target and its businesses. And as we saw in the previous case, there were some contractual limitations in the agreement in relation to any claims under those warranties. So, in particular, written notice of a warranty claim had to be given within 24 months of completion. So, I'm going to call that the notice period. So, you've got to notify within 24 months of completion. And then legal proceedings in respect of a notified claim had to be commenced within a further 6 months of the written notice. So that's, I'm going to say, call that the litigation period. So you've got 24 months to bring a claim, and then once you've notified a claim, you've got 6 months within which to issue proceedings. And then, for any claim that's based on a contingent or unquantified liability, the litigation period, so the period within which you had to start your proceedings, didn't begin until that liability had become either an actual liability or capable of being quantified. So, after completion, perhaps unsurprisingly, that's why we're talking about it, the parties were unable to agree the calculation of the earn-out consideration. And so, in accordance with the relevant mechanism set out in the agreement, the matter was referred to an independent expert for determination. Separately, so we've got that going on, we've got the dispute about the earn-out consideration going on, but separately, the buyer also gave notice of various warranty claims to the seller. And that notice was given within the notice period. So it was given within that 24 month of completion period. The buyer subsequently commenced its proceedings in respect of the warranty claims within 6 months of the earn-out calculation being determined. But that was more than 6 months after the initial notification of the warranty claims. And according to the seller, that meant that the claims were time barred. So remember, a warranty claim had to be notified within 24 months of completion. Yep, fine. The buyer did that. And then proceedings had to be issued within a further 6 months. So that didn't happen here. But what did happen is the proceedings were issued within 6 months of the earn-out consideration being determined. Now, the seller, because the seller says, well, you haven't complied with the time limits, your claim is time barred, the seller applied for strikeout of the claims and or summary judgment dismissing the claims. But the buyer argued that because certain matters that formed the basis of its warranty claims also affected the calculation of the earnout, its warranty claims were not actual or quantifiable liabilities until the earnout calculation had been completed. And therefore, the buyer said, well, actually, the litigation period, the period within which, that 6-month period within which we have to commence our proceedings, that doesn't start until the earnout had been determined. So when it went before the court agreed with the buyer and refused the seller's application for strikeout and summary judgment. So remember, the seller had argued that the calculation of the earnout consideration, which looked at the target's value 12 months after completion, was unconnected with the valuation of the warranty claims, which looked at the target's value at completion. But the judge said that it was a misconception to suggest that there was no connection between them. The judge said, well, they're both based on an EBITDA figure projected forward for about 10 years. And that meant that if, for example, there was an undisclosed ongoing overhead, then that could actually affect both the target's value at completion and its value at the end of the earnout period. So taking that overhead into account in both a successful warranty claim and in the calculation of the earnout could result in the buyer benefiting from a double price reduction, which would be very wholly unjustifiable, as the judge said. So the court also said that a claim for breach of warranty is a claim for loss based on the difference between the buyer's actual position given the breach and the position it would have been in had the breach not occurred. And in this case, the buyer's actual position, so the total amount it had to pay the seller for the target business, could not be known until the earnout consideration had been determined. Only at that point did we know actually the total amount that the buyer had to pay. So that meant that the warranty claims were contingent and unquantifiable until the earnout consideration had been determined. So, although in this case the judge did find in the buyer's favour, that isn't actually the end of the matter. Remember, this was just a claim by the seller for an application for strikeout and summary judgment. That claim having been dismissed, the case will now have to proceed to trial in order to determine the actual merits of the buyer's underlying warranty claims. But I think the case is a useful reminder of the need to give careful consideration, particularly to the interaction between warranty claims and any price adjustment mechanism in the agreement. And you need to ensure that any interdependent timetables work appropriately, and also that there's no possibility for double counting the same liability, or indeed the same asset, under the two matters, which could potentially result in a windfall to one party or the other, or indeed a liability for one party or the other. Okay, so those are the two warranty claim cases. Now, the third case that I was going to mention involves an unfair prejudice claim. And here the court held that a company shareholder had suffered unfair prejudice when the company's sole director arranged for the sale of the company's main asset to another entity that was owned by that director. And the sale had taken place at a price significantly below the asset's true market value. Now, I've talked about unfair prejudice cases before, but let's have a bit of an explainer to give some context to this particular case. So, an unfair prejudice claim is the main procedural route for a minority shareholder to petition the court when they believe that the company's affairs are being conducted in a manner that's unfairly prejudicial to their interests as a minority shareholder. So, for the claim to be successful, the conduct that the shareholder is complaining about must relate to the company's affairs, and that could mean management decisions, or it could be disruptive attempts by shareholders to exert greater control over the company. It must relate to the members' interests in their capacity as members, and it must be prejudicial to the member and unfair. So the courts are much more likely to find that conduct is unfairly prejudicial if the relevant company is what's called a quasi-partnership. So that could be the case, for example, where the company's been established based on mutual trust and confidence between the founding members, or where there's an understanding that, for example, all or some of the shareholders are going to be involved in the conduct of the business. So you're saying, well, yes, it is a company, but it's a bit like a partnership in terms of the relationships between the founders and their expectations about their involvement. So if an unfair prejudice petition is successful, the courts are given a very wide discretion to make any order that they think fit to grant relief. So, in many cases, what the petitioner will ask the court for is a buyout order where the other shareholders are required to buy out the petitioner's shares at their fair value. So, in this particular case, we had two individuals, Mr. Simpson and Mr. Diamandis, and they'd set up a company in which each of them held 47.5% of the shares, and then the remaining 5% were held by the company secretary. So, Mr. Diamandis was the company's sole director, but Mr. Simpson had been heavily involved in all strategic decision making. The company subsequently acquired the shares in another company that had previously been owned by Mr. Simpson, and that subsidiary was the company's most profitable asset. So several years later, Mr. Diamandis and a third party investor devised a scheme whereby the shares in the subsidiary, remember that valuable asset, would be transferred to a new company. And under the initial plan, Mr. Simpson and Mr. Diamandis were going to hold an equal number of shares in that new co. But actually, by the time the scheme was finalised, Mr. Simpson hadn't been allocated any shares in it at all. So, as the sole director of the original company, Mr. Diamandis approved the board documentation for the reorganisation. And the company also passed a members' written resolution approving the sale of the subsidiary to the new co for about £150,000. Mr. Simpson did object to the resolution being passed, but remember, Mr. Diamandis and the company secretary together held more than 50% of the shares, and therefore they had enough shares to pass that ordinary resolution. So Mr. Simpson then petitioned the court on the basis that the shares in the subsidiary had been worth £2.9 million at the date of the transfer, which was obviously considerably more than the £150,000 that had actually been paid by Newco. Mr. Simpson claimed that the transfer of the shares at such an undervalue to a company controlled by Mr. Diamandis, and in which he himself, Mr. Simpson, had no shareholding, amounted to unfair prejudice. And Mr. Simpson also claimed that the transfer of the subsidiary at an undervalue was a breach of Mr. Diamandis' duties as a director and in breach of the quasi-partnership relationship that existed between Mr. Simpson and Mr. Diamandis in relation to the company. So the court agreed with Mr. Simpson, perhaps unsurprisingly, and did say that yes, he had suffered unfair prejudice as a result of the sale of the subsidiary to Newco at a substantial undervalue. So, in relation to its finding of prejudice, the court held that the transfer of the subsidiary had resulted in the value of the original company. Remember, that's the one in which Mr. Simpson held his shares. That value had been reduced by approximately £2.75 million. And the court said it was hard to conceive of a clearer example of the economic value of the petitioner's shareholding being seriously diminished by reason of the conduct on the part of a person with de facto control of the company, namely Mr. Diamandis. So Mr. Diamandis's actions as sole director were properly regarded as the conduct of the affairs of the company, and that conduct had indeed been prejudicial. And then the court also held that that prejudice suffered by Mr. Simpson was indeed unfair for several reasons. In particular, the business relationship between Mr. Simpson and Mr. Diamandis was based on mutual trust and confidence in each other. So it was a quasi partnership. And it was a clear breach of that trust and confidence for Mr. Diamandis to deprive Mr. Simpson of the value of his shareholding in the company, whilst preserving the value of Mr. Diamandis' own shareholding. It was also a breach to cause the company to sell its principal asset at an undervalue in order to benefit himself, Mr. Diamandis. And it was also a breach to ignore professional advice and fail to obtain a valuation of the shares in the subsidiary. And the court said, in addition to that breach of trust, Mr. Diamandis' actions had also constituted a breach of his fiduciary and statutory duties as a director of the company. And the remedy that the court ordered was for Mr. Diamandis to buy out Mr. Simpson's stake in the company. So a fairly straightforward case of unfair prejudice, I think, particularly given the significant and obvious prejudice that was caused to Mr. Simpson by the transfer at such an obvious, significant undervalue of the company's most valuable asset. But I think the case is a very useful reminder that where individuals are in that kind of quasi partnership role, and that isn't, by the way, a complete prerequisite to an unfair prejudice, a successful unfair prejudice claim. You can have an unfair prejudice claim where there isn't that kind of relationship, but where there is that quasi partnership relationship, then additional equitable considerations will be taken into account, and conduct may still be unfair, even when it's carried out in a procedurally correct manner. So in this instance, remember the transfer at an undervalue had in fact been blessed by an ordinary resolution of the company's shareholders, and its sole director had signed the necessary paperwork. So all the sort of statutory requirements or technical requirements had been complied with, but the transfer was still held to be unfairly prejudicial to Mr. Simpson. Okay, that was it for cases this week. But then finally, I thought I would just mention the proposals by the Takeover Panel to significantly reduce the scope of companies to which the UK's Takeover Code applies. And that code is there to offer, in particular, the shareholders of that company significant protections, and indeed the company, but when it's faced by a bid for those shares from a potential suitor. So the Takeover Code is primarily aimed at regulating takeovers of UK companies that are listed in the UK. But actually, its scope is much wider than that. So, for example, the code applies to private companies if they have been listed at any time in the previous 10 years. And it also applies to public companies that are either unlisted or are listed on an overseas market. And in each of those cases, the code will apply where the company satisfies what's known as a residency test, because it has its place of central management and control in the UK, the Channel Islands, or the Isle of Man. So, under the new proposals, the code would only apply to a company that is, or relatively recently was, both UK registered and UK listed. So, to be subject to the code, a company must have its registered office in the UK, the Channel Islands, or the Isle of Man. That means it's a UK registered company. And then either the company must have its shares or securities admitted to trading on a UK regulated market, or a UK multilateral trading facility, or a stock exchange in the Channel Islands or the Isle of Man. So that would mean it's a UK listed company, or the company must have been UK listed, so had its shares admitted to one of those markets at any time in the previous 3 years. So where we're talking about UK regulated market, that could be the London Stock Exchange's main market, a UK multilateral trading facility, that would be a market such as the AIM market, the Channel Islands stock market, that would include the International Stock Exchange based there. So a company must be UK registered and UK listed, or either currently or in the last 3 years. So because of these proposals, that will mean that various companies will fall outside the scope of the code. So companies that are currently within scope will fall outside of the scope. So that means that, for example, the code will no longer apply to a company that was UK listed more than 3 years ago, or a company whose securities are only listed on an overseas market, or an unlisted public company, or, for example, a private company that has filed a prospectus during the previous 10 years. And in addition, that residency test that I mentioned, that's going to be abolished, meaning basically that companies only listed on an overseas market would fall outside the code, even if their place of central management and control was inside the UK, the Channel Islands, and the Isle of Man. So I think the sort of big picture here is that the proposals are aimed at focusing the application of the UK Takeover Code on just those companies with a close connection to the UK and to which the code might be expected to apply. Over recent years, there's been a number of UK companies that have chosen an overseas market for their primary listing, particularly the New York Stock Exchange or NASDAQ based in New York. And the proposals in the consultation would mean that those companies, and indeed their shareholders, will lose the code protections in relation to bids and other changes of control. But if it's a UK company that's listed on, for example, a US market, then because it's not a US company, they actually may also fall outside the scope of the US rules governing takeovers. So companies are going to have to think about this if they fall into that category of a company that was previously protected but will no longer be protected. There is a 3-year transition period proposed. So what one of those companies might do is use that transition period in order to build into its constitutional documents some appropriate provisions to provide protection from unwanted suitors once the code protections fall away. So the consultation closes at the end of July, and the takeover panel, has said it expects to publish a response statement in autumn of this year, and then any changes to the code would be expected to be implemented 1 month after the response statement. But then, as I say, there will be a 3-year transition period to allow companies time to adjust. That's it for this month. Hope you found that interesting, and I'll speak to you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.